Hello, people. Welcome to Undisclosed, Episode 9, The Gnant Pod. As always, I'm going to start by reminding you that it is way better to listen to the actual Undisclosed podcast, but I am going to do my best to summarize for you and to summarize quickly. But there's a lot going on. Rabia starts by reminding us that her theory is that the police fixed on Adnan as their culprit really early on, and therefore they stopped truly investigating the case because their focus was on building a case rather than on finding the truth. One of the things they figured out along the way was that Adnan wasn't with his car or his phone all day, so they had to bring Jay into the narrative. But that sounds really kind of conspiratorial. Why would the police do that? Did they have a vendetta of some sort? What about Jay? Why would he implicate himself in a crime unless he was actually involved? The jury also wondered that. Why on earth would he cooperate with the police against Adnan? And what could the police possibly have over him to get him to testify, other than some pot charges? The purpose of this episode is to answer some of those concerns in sort of a roundabout way. Some of you guys are going to like this episode better than other episodes we've listened to because we're going to get away from Adnan's case a little. We're going to see how any and all of this stuff could happen because it has happened before, and we're going to see that by looking at all of these other cases that are the topic of this episode. So as you listen, I want you to think about a couple of things. I want you to pay attention to who the characters are who overlap between this case and Adnan's case. And I want you to pay attention to what the parallels are. What are the connections to Adnan's case? Some of them I'm going to point out and they're going to be really obvious, and some of them you're going to figure out on your own just kind of as you listen. So the first thing we need to talk about is the fallibility of the system itself. There are flaws in the system, and that's what impact individual investigations and then result in wrongful convictions. Here's an example. A 2008 investigation into the Baltimore City Crime Lab found that in at least 9 homicide, sex assault, and burglary cases, the detective told the lab technician not to follow up on convicted criminals' DNA that was found on evidence at crime scenes because they, the detectives, had determined it was not relevant to the investigations. That means the detectives or the technicians found DNA that was tied to convicted criminals, but the detectives told the technicians not to follow up on that DNA they found because it didn't fit their theory of the case. In response to an article about those findings, the Baltimore State's attorney requested a review of the cases handled by the lab and said that both the prosecutors and defense attorneys needed to be made aware of all of the evidence the police collect. And that seems to imply that they weren't previously being made aware of it, because why would she have needed to say, hey, let's start doing this, if they were already doing it? Later on, it was discovered that 12 other unknown genetic samples and evidence were found to be the DNA of lab employees themselves. That's a lot of contamination, and other forensic experts have said that's an indicator that there was likely significantly more widespread problems going on. Then there's the police and the prosecutor's office. For example, detectives were charging loser cases to boost their stats. What that meant was that the prosecutors had to take on really bad cases from the police. One specific example is in 1998-99, Detective Ritz, as in Ritz and McGillivray, Detective Ritz was a part of 42 murder cases that got marked as solved because he charged someone for the crime. Out of those 42 cases, 15 of them were dismissed by the prosecutor's office prior to trial because they didn't have a strong enough case. So more than 35% of the cases that were marked as cleared by the police were not investigated well enough to have a case that could convict at trial. They were charging before they had done a complete investigation. But because of your right to a speedy trial guaranteed under the Sixth Amendment, the prosecutors only get so long before they have to either go to trial or let you go. The prosecutors didn't have enough time to fully investigate all of the holes left in the cases by the police. So the police weren't investigating, then they were charging, and then the prosecutors were having to go ahead and do more investigation in order to have enough in order to actually do the trials. And they just didn't have time for that, so they kept having to drop cases. Around 2000, the charging rules did change for Baltimore. So the charging documents had to be filed by both the detectives and the prosecutors. So it is logical to conclude that this wasn't just a Ritz problem. This was a more consistent Baltimore police problem. There was also a systematic pattern of Brady violations. Remember that a Brady violation is when the police or prosecutors suppress exculpatory evidence. The idea of a Brady violation is one that really challenges what we've been taught our whole lives about the whole officer-friendly thing. Why would the police do that? Would the police really do that? Would they really hide evidence that shows someone is innocent? Would they really take a chance that they're convicting an innocent person? Well, let's look at some cases. So here's the first case. It's the state of Maryland versus James Owens. So in 1987, Colleen Willier was found dead in her home, having been stabbed, strangled, and sexually assaulted. A guy named James Thompson lived in the area and went to the police with a knife he said he'd found in a grassy area near her home. Thompson said it was his knife, but it had gone missing in the days before Willier's murder. If you're into classic films, this is the same claim made by the defendant in 12 Angry Men, that his knife went missing and was then used in a crime. Later on, Thompson confessed to being an accomplice to the murder, which he said was actually committed by James Owens. Thompson said that Owens told him he'd had sex with and then gotten dope from the victim, and then told him the location of the knife. But later on, Thompson's story changed as many as 6 times, often on key details. For example, at one point, he changes to say that Owens actually brought him the knife, as opposed to just telling him where it was. A later court actually commented and said, when Thompson finally testified at Owens's trials, his testimony was inconsistent with the chronology of events the morning after the murder, and appeared so untruthful that the prosecutor was worried about the prognosis of the case. Nonetheless, Owens was convicted of felony murder, although he was not found guilty of rape. Thompson himself was also convicted of felony murder and also convicted of rape. Fast forward to 2008, Maryland has a new DNA testing statute, and Owens moved to have the DNA in his case tested. Sperm were recovered from Willier's body and finally tested. Who do you think the sperm belonged to? Wrong. It didn't belong to Owens. But it didn't belong to Thompson either. It belonged to some other unidentified third person. As the appeal process went along, it popped up that the state had also failed to disclose key evidence to Owens. It turns out the police interviewed Owens' boss. At the same time that Owens was supposedly confessing to Thompson and handing him the knife, Owens was actually at work. So Owens' conviction was thrown out, the state decided not to re-prosecute, and in 2011, Owens filed suit against the police officers and prosecutors who handled the case. This has a parallel with Serial because it was pretty much framed as either Jay or Adnan the whole time who killed Hay. This case did the same thing, and Thompson implicated himself just like Jay did. So you end up with the same kind of thinking. Either one did it, or the other did it, or some combination of the two. But in this case, it was neither. So that could also be the case with Hay's murder, and we've discussed that. Fun fact, although the charges against Owens were dropped, Thompson ended up having some of his charges dropped and others held up. He eventually entered what's called an Alford plea. That means he did not confess guilt, but he did sign off saying that he knows the prosecution has enough evidence to convict him, mainly his own statements. So he'll accept a guilty conviction for a reduced sentence. This saves the state money from not having to go to trial and lets Thompson reduce his sentence without actually admitting any guilt. Colin also points out that if they don't have to go to trial on Thompson, there is no factual record being created that Owens could potentially use in his case against the police and prosecutors. So by allowing the Alford plea, by allowing Thompson to not actually be convicted in full guilt, they don't have to put information out there that maybe then Owens could use to say, no, here's some shadiness that happened in my case. All right, well, moving on to case 2. This is the state of Maryland versus Toni Williams. In February 1998, Dana Rochelle Drake was fatally shot outside of her apartment complex in Northeast Baltimore. She died of a gunshot wound to the head and another to her back. Toni Williams was the one who called police and took them to her body. He told police he'd been previously romantically involved with the victim, but he was not currently romantically involved with her, and that the victim's new boyfriend had threatened to kill her. The police officer recorded that Williams didn't seem particularly sad or unhappy and didn't inquire about whether she was still alive, but he was calm, polite, and cooperative. A couple of months later, Williams was arrested and charged with both first and second-degree murder. He was in jail, and his cellmate, Sean Williams, went to officials and said that Toni Williams had confessed to him. Based on that statement, and based on the state's theory of the crime that Toni Williams had killed Dana Drake for insurance money, Toni Williams was convicted of the crime in 2003. Sean Williams said that he was only giving information against Toni Williams out of the goodness of his heart, and because he disliked violence and guns. Detective Massey testified that Sean Williams had received nothing in exchange for his testimony against Toni Williams. Well, do you remember Massey? He's the one who took the anonymous phone call that allegedly pointed to Adnan. So a few years after Toni Williams' conviction, a post-conviction relief motion was filed on the grounds that Sean Williams had actually been a paid informant, and this information had been withheld from the defense. It turns out that even though the police and prosecutors went on the record under oath saying that Sean Williams hadn't gotten or even asked for any sort of consideration in exchange for his testimony, there was documentation proving he absolutely asked for and received consideration in the form of having a previous case for stealing a police car steaded. Now, remember from Jay's deal that having a case steaded means that the charges are placed on the inactive docket and then they never really get prosecuted. Not only that, but Sean Williams had done this before. He says multiple murderers have confessed to him in the jailhouse, and he testified against each of them. He even had his own confidential informant number. Well, based on that, Toni Williams' conviction was overturned. And this isn't just disturbing because they withheld the information about Sean Williams being a repeat confidential informant, but because a detective flat out lied under oath about him not having asked for anything in return for his testimony. In one U.S. Supreme Court case, the ruling says that it doesn't matter what the prosecutor does or doesn't know. If the police or detectives have this information, there's an obligation for the prosecution to find that out. So in Adnan's case, even if the prosecution didn't know about police misconduct, that's still enough for a Brady violation, just like it was in this case. Now, in the Williams case, it's even more upsetting because they found out that some members of the prosecution team did know about the confidential informant thing and just didn't disclose it. Williams was retried in 2007 and was convicted again. But then that conviction was reversed. It came out just before the second trial that the other witness in the case, the one who says she saw Toni Williams from a distance right after the shooting, had disclosed to Detective Massey that she was legally blind. And Massey had never disclosed this to defense. Well, he did right before the second trial, but that witness had died before the second trial. However, her testimony at the first trial was allowed to be played in court at the second trial. Of course, she was dead by this time, so the defense never had a chance to cross-examine her or impeach her knowing this information that she was legally blind. So a second conviction was obtained, and then eventually that was overturned on appeal. But wait, we're not done. Williams was tried and convicted a third time in 2011, this time with the testimony of another jailhouse informant who said that Toni Williams had confessed to him. Apparently, Toni Williams just can't stop confessing. So you take from that what you will, but there's a lot going on in that case. All right, case number 3, State of Maryland versus Raymond Brown. In 1995, Raymond Brown was charged with the first-degree murder in the shooting death of Michael Kent. In October of 1995, a guy named Carlos Austin was arrested and charged with a totally different murder. The very next month, November 1995, Detective McGillivray goes and speaks to Austin, the second guy, in the office of his own attorney. Arrangements are made and Austin's father drives him to the homicide unit where Austin makes a recorded statement. And in that statement, he identifies Raymond Brown as the murderer of Michael Kent. Remember, these were two totally unrelated murders. It's not that he was saying, no, Raymond Brown murdered that guy, not me. It was a whole other case. Trial was scheduled, but in March of 1996, Austin decided to go to the office of Michael Kent's attorney. While he was there, he made a statement. They read the whole statement in the podcast at about the 23-minute mark, if you want to hear it. But pretty much it says he did not see the shooting. He did not see Raymond Brown shoot anyone. He was in the area and he heard a bunch of shots. That's all. He said that the reason he told police he'd seen Raymond Brown do it was because he'd heard that Raymond Brown was trying to get the friends of his alleged victim, a guy named Valjean, to tell the police that he, Austin, had killed Valjean. He says he thought it would be a way to get even with Raymond Brown, even though he did not actually know who shot Michael Kent. So this actually reminds me of the Central Park 5 case where it's like, hey, they're going to say you did this. And, he says, well, I'm going to get back at them. Except this time they're tying together completely separate cases. Now, even though Austin made this statement, the state decided to move forward and prosecute the case against Raymond Brown. At trial, they decided not to call Carlos Austin as a witness, for obvious reasons, but they do call Detective McGillivray to testify. Somehow, even though the defense strenuously and repeatedly objected, McGillivray was allowed to testify about the earlier statements Austin had made implicating Raymond Brown. The court also allowed the statement to the attorney to be admitted into evidence, but did not allow the defense to ask McGillivray whether or not Austin was charged with the murder of Val Jean at the time he made the false statement and identification. So essentially, they're allowed to enter the first statement into evidence, even though they know that the witness has recanted his statement. The podcasters wonder if it was actually the police who floated the rumor that inspired Carlos Austin to make a statement against Raymond Brown in the first place. They also really emphasize how completely messed up it is that prosecutors had the second statement saying that the first statement was garbage, but they still went through with the case. And the kicker is that Raymond Brown was convicted based only on this statement, which they only know about through McGillivray and no forensic evidence. So is it possible that the police didn't have anything on Jay, even pot charges, and it was actually just that he'd heard some rumor that pissed him off about Adnan, so he decided to pin the murder on Adnan? Maybe. There is that time that Jay told Jen something like, "I'm telling you what happened so you know I didn't do it, so you know what really happened," which could mean he'd heard that someone was going to point the finger at him, or Adnan was going to point the finger at him, and he just wanted to get that finger pointing the other way instead. Who knows? Case 4 is the state of Maryland versus Sabian Burgas. This is a recent case. Burgas was exonerated and released from prison in February of 2014. Fun fact, Burgas and Adnan were actually incarcerated in the same place at one point, and Adnan got to know Burgas. Burgas had converted to Islam, and since Adnan knew all the Muslim inmates, they came to know one another. So here's the story. In 1995, Sabian lived with his girlfriend, Michelle Dyson, and her 4 kids. One evening, he left the house, and when he came back, he found her dead in the basement from multiple gunshot wounds. He ran to a neighbor's house for help, asked them to call 911, and then went back to the house and tried to save Michelle by clearing her airway. There's a passage in the podcast at about the 29-minute mark from the Baltimore Sun about what happened when the police got there. They had Burgas come out with his hands where they could see them, they cuffed him, and then they swabbed his hands for gunshot residue. The crime scene tech swabbed the insides of his palms. Now, hopefully in your head you're like, insides of your palms, that's not where you swipe for gunshot residue. Well, you can, but then you should also be swabbing, remember, the sides, like the tops kind of where your thumbs are, and the sides of your fingers, and then the tops of the hands and the webbings too. So a month later, the GSR test results came back, and they came back positive. The guy who conducted the test, named Van Gelder, testified at trial that he had found the gunshot residue particles in the webbing between Burgas's fingers, and that could have only happened if Burgas had fired a gun, because that's the only way GSR particles could get to that part of the hand. He also testified that the GSR could not possibly be transfer evidence. Based on that, Burgas was convicted of the murder. So hopefully right now you're thinking about all the kinds of problems with this evidence. The technician testified that the sample had come from the webbing of the fingers. But remember, he didn't swab the webbing of the fingers. He swabbed the palms of Burgas's hands. The technician also testified that gunshot residue can't be transfer evidence, and it totally can. They don't really explain this in the podcast, so this actually is a Gnant pod bonus that you're getting. There's something called bullet wipe. That happens when the bullet hits its target, and on the way in, all of the residue that's on the outside of the bullet wipes off onto the clothing or skin of whatever it's going into. So even though the primary source of GSR is from that puff of residue when the gun is fired, there is also going to be GSR found on the bullet wipe. So if Michelle Dyson was shot multiple times and Burgas had his hands all over her trying to clear her airway and stop bleeding, it would make sense that some of that GSR would transfer off the bullet wipe locations and onto the palms of his hands, which is the part of his hand that was actually swabbed. In fact, the FBI no longer now even uses GSR evidence, and a big reason why is that contamination is a huge problem. Also, Van Gelder himself has a bit of a past when it comes to GSR. In a previous case, he was found to have testified that he found 17 unique particles, although the paperwork showed that only a single unique particle was found. Now remember, we talked about how the amount of transfer is something that you need to look at when you're looking at transfer evidence. So if only a single particle is transferred compared to the 17 that he talked about, that makes it way more likely that you're looking at accidental contamination as opposed to an actual true transfer of evidence. In a different case, Van Gelder's GSR testimony actually led to the dismissal of a manslaughter charge against a Baltimore police officer who had shot and killed a 14-year-old boy in 1993. The boy and his friends were running away from the officer at the time of the shooting. The boy was unarmed, but the officer said that as the boys were fleeing from him, he'd been fired upon, and he had just fired back. There was no evidence other than the officer's word that he'd been fired at until 6 years later when Van Gelder came onto the case. He did GSR testing on the boy's hands and said that it had come up positive. The charges against the officer were dismissed because of Van Gelder's testimony. The officer's attorney referred to it as divine intervention. The chief of the investigative bureau said, "It speaks of the good credit of the lab technician who, on his own initiative, knew of a test that is more accurate and more up to date." Well, the podcasters are pretty certain there was not actually any test that was more accurate and more up to date. It was just Van Gelder swooping in to help out a police officer with extremely convenient forensic results. But let's assume that Van Gelder actually did find GSR on the boy's hands, even though, remember, the boy had no gun. So where had that GSR come from? Well, in 2001, an internal study by the Baltimore City Police Department found background GSR contamination at high levels in areas of police stations where suspects and witnesses were processed for GSR collection. More research in 2001 found that unique GSR samples were found in the air and on the furniture at basically every other place that was sampled in the 4 different police stations that were part of the study. So it could be that just going to the place where you'll be swabbed for GSR could put GSR on you that is then swabbed off of you. Even after they removed GSR testing from these common areas, another study showed that the cleaning bucket, floors, and police officers' handcuffs all had GSR on them. Sarah points out that unless buckets and floors and handcuffs are out there firing weapons, the connection between presence of GSR and having fired a gun is a false connection. So Colin brings up how this case is connected to chain of custody issues and documentation. Remember, they tested a red fluid on a t-shirt found in Hayes' car, but the blood samples for Hay and Adnan had already been opened without any kind of explanation. And there's the issue with the windshield wiper lever or turn signal lever, whichever it was, that wasn't videotaped until after the car had been released to Hayes' family. Bonus information, it turns out that it was Van Gelder who had done the fracture match on that lever in the car. Okay, back to the Burgas case, though. The police reports say that the 4 kids were asleep upstairs. But one of the 4 kids, the victim's son, actually told police on the night of the murder that Sabian Burgas was not responsible. He had seen someone barge into the house on the night his mother was killed, and he said that it was not Sabian Burgas. But the police didn't record it, and they didn't hand it over to the defense. It wasn't until many years later that the defense team discovered through a formal records request that the son had made this statement. It was recorded, like verbally recorded, but it was not included in the files that were handed over. So, Burgas had a 2-day trial and was convicted and sentenced to life in prison. 2 years later, the real perpetrator, a guy named Charles Dorsey, wrote a letter confessing to the crime. He actually wrote several letters at several different times saying that Burgas was doing time for a murder that he, Charles Dorsey, had committed. A year later, Detective Ritz and another Baltimore detective interviewed Dorsey in prison, but then they did no follow-up. They said that his confession lacked details that the real killer would know. But Dorsey had told them the caliber of the weapon he'd used, the correct number and location of the gunshot wounds, and that he'd moved a safe with money and personal papers from a second-story bedroom. He said that he and another guy had forced their way into the home, and they'd both shot and killed the victim in the basement. The real kicker is that way back in 1996, before Burgas was convicted, Dorsey was already on the radar of the investigators. One of them had actually asked a witness directly if Dorsey could have been involved. So they somehow knew there was a connection there, but didn't pursue it. Then, even after he confessed years later, Ritz concluded that Dorsey knew nothing about the murder and wasn't involved. But clearly Dorsey committed this crime. So either Ritz isn't bright enough to realize when the real killer is confessing and giving accurate details, or he knew that the real killer was confessing and he just didn't care. So here Colin talks about the tunnel vision in Adnan's case. They said something like, "Of course the boyfriend did it. Who else would have?" So they had their theory of the case, and they collected evidence that confirmed what they were already thinking. Confirmation bias led them to find the parts of the evidence that fit their theory and ignore the parts that didn't help them. Sarah lists out all the ways Burgas was in a terrible place with this case. The forensic evidence was portrayed in a way that just wasn't true, saying that transfer couldn't have happened when it really could have. He wasn't told that there was a witness when really there was one. and the police just wrote off the lack of a gun as his having disposed of it on the way to call 911. She then points out that in Adnan's case, there were notes from April of 1999 that were never handed over to the defense, like the interview with the track coach and Becky's statement that Hay told Adnan she couldn't give him a ride that day. Colin discusses how the GSR in the Burgas case is analogous to the cell tower evidence in Adnan's case. Remember that prosecutors sometimes complain about the CSI effect, saying that jurors expect forensic evidence, and when it's not there, they tend to exonerate at a rate that doesn't match reality. But Colin says that studies have shown that the CSI effect doesn't actually exist, and jurors aren't really that hung up on requiring forensic evidence. What they have shown is what Colin calls the reverse CSI effect, where juries actually tend to overvalue whatever science is presented, without acknowledging the risks of contamination and the ways in which forensic evidence can't actually tell us what we think it can tell us. So in other words, they don't require the forensic evidence, but if the forensic evidence is there, they are all about it and completely buying in. So the connection the podcasters make is that in Burgas's case, the GSR testing was described as a science that was given too much credibility, just like the cell tower evidence was given too much credibility in Adnan's case. Of course, that's in addition to the withholding of information witnesses made in their statements. All right, moving on to the fifth case. Ezra Mabel was convicted of killing a drug dealer, Kevin Dukes, in August of 2000. They actually referred to this case once before, so you might remember it. Right before Kevin Dukes was killed, he learned that one of his dealers, a guy named Eddie, had been cutting the drugs before selling them and pocketing the money from the extra sales. Their relationship naturally deteriorated, and Dukes told one of his friends that he was trying to get a gun for his own protection because he was afraid Eddie was going to kill him for his drugs. The day of the murder, he met with his dealers for their weekly meeting, and immediately after the meeting, Eddie was seen getting into Dukes' vehicle. Soon after that, Dukes was found dead, having been shot multiple times at close range. Detective Ritz and Detective Hastings were the lead investigators on the case, and quickly after arriving at the scene, they decided that Dukes had been killed while sitting in his car. Rabia throws in an aside that a later complaint states how the physical evidence was not consistent with that, but whatever. The police didn't find any witnesses at the scene, but in the days following, they received numerous tips identifying Eddie as the shooter. A few weeks later, 2 officers ran into Eddie on the street and determined that he was the man tipsters had identified as the murderer of Kevin Dukes, so they picked him up for questioning. But when the officers took him back to the station, their supervisors told them that Eddie was not wanted as a suspect. Ritz was contacted, and he was told that Eddie had scars on the back of his neck, and that those scars were consistent with some of the tips they had gotten that Eddie was scratched on his neck before he killed Dukes. But Detective Ritz, acknowledging this, still advised the officers to release him. So Eddie was never questioned, and there was never any DNA testing ordered. Even though Dukes had scratched his killer before his death and scrapings from under his fingernails were taken, they were not tested for DNA. Now, Ezra Mabel eventually was convicted, and I'll tell you how in a second, and he was later exonerated. But in his complaint against the Baltimore City Police, he notes that the police department repeatedly ordered the crime lab not to conduct DNA tests. So the police had no forensic evidence, no motive, and no witnesses to Ezra Mabel committing this crime. How did they get a conviction? Well, Rabia says that they did it by inventing eyewitnesses. 2 of them. Early in the investigation, one woman had told the police that another woman, named Ms. Frazier, might know something about the murder. 2 months later, they contact Ms. Frazier, but at that point she has no interest in meeting with the police. Over the next couple of days, the officers repeatedly phone her. She ignores them, and they eventually stake out her evidence. One night, in the middle of the night, they pull her over on the side of the road. It's pitch black, middle of November. They search her car, and they find some drugs. We don't know how much or what it was, but there is an allegation that the police planted the drugs. But of course, that's something we can't prove. As it's going from night into morning, so a bunch of time has gone by now, Frazier is shown a mugshot book with black and white photos of African-American men's faces. She's essentially given a choice. Either identify someone in the photo book as the shooter of Kevin Dukes, or be arrested for possession of the illegal narcotics they found in her car. Well, she's got her kids in the car. They're threatening her with drug charges and having her children taken away from her. So she decides to pick a photo and roll with it. And it turns out the photo she picks is Ezra Mabel's photo. But 10 minutes later, as she's signing the photo of the person she has picked as the person who committed the crime, she signs a different picture. It's a picture of a different African-American man. But his skin is lighter. He's not chubby like Mabel is. He has hair that extends beyond his ears, which is different from Mabel's hair. and he's about 10 years older than Mabel. Guess whose picture she signed? It was Eddie. She even wrote next to the picture that she was sure that this person was the shooter. The next day, she's interviewed again. She has only the vaguest of information, and according to her, tells the police that she didn't even really see the shooter. She just saw a guy get out of the passenger side of Mabel's vehicle. Then there's the second eyewitness. Taylor was another local woman, but there's not really any connection between her and the case, and we don't know why she would have been looked at as someone who might have information. Nonetheless, the police make her an offer she can't refuse. Make an identification, and you won't be arrested for possession of narcotics. But Taylor's statement didn't match Ms. Frazier's. She couldn't even provide basic details. She got facts wrong, and she kept changing the facts she did have. She couldn't even locate the friend's house where she said she was at the time of witnessing the murder. She also said things like that the killer got out of the driver's side door, when Ms. Frazier had said it was the passenger side door. Despite all these inconsistencies, she was given a photo array, just like Ms. Frazier had been. When she picked out the killer who she'd witnessed, she picked out Eddie. So we have one witness who identifies Ezra Mabel, then Eddie, and a second witness who identifies Eddie. But at the grand jury hearing, Detective Ritz testified that two witnesses, including Ms. Frazier, identified Ezra Mabel as the shooter. Notice, he names Ms. Frazier as one of them and leaves the other unnamed. No information is shared about Ms. Frazier or Taylor identifying Eddie, not to the state's attorney, not to the court, not to Mabel's attorney. But being faced with two eyewitnesses and knowing how much juries love eyewitnesses, upon the advice of his attorney, Ezra Mabel takes a plea. He pleads guilty to second-degree murder. He was sentenced to 25 years. But 7 years later, in 2009, he wrote his own appeal for post-conviction relief without an attorney's help. That's an appeal that says, hey, my case is over, but here are some reasons I should have my sentence shortened or overturned even. Here's what's kind of crazy. He was doing this without an attorney, but the Baltimore City State's Attorney's Office decided to join in with his motion and requested that he be released. That motion was granted in 2010. This is highly unusual, to say the least. That only happens if there's something truly horrible and egregious in the case file that the prosecutors feel like they have absolutely no choice but to deal with it in a way that makes it go away as quickly and quietly as possible. Collins says this is similar to the Owens case back at the beginning and makes him ask the same question. Did the state's attorney's office agree to the motion because they didn't want to have to go on the record and create a factual record as to what was and was not done in the case? That's significant because in 2013, Mabel filed a civil suit against the Baltimore Police Department and Detective Ritz for their role in securing a false conviction. This is where Collin inserts the disclaimer that the information they've shared so far in summarizing this case has come from the briefs filed when Mabel brought this civil case, so it does all have to be taken with a grain of salt, so to speak. But here's the main idea of Mabel's complaint, and it's a quote from Mabel's complaint. The detectives resolved to focus entirely on Mr. Mabel and did not attempt to determine the actual truth in their investigation or to develop a case based on truthful facts. Motivated by a desire to quickly solve Mr. Dukes' murder and make an arrest in this highly publicized case, the defendants, the Baltimore Police Department, adopted a theory and then abused their investigation and authority to construct a case to fit it. It sure does seem like that's what happened, given the fact that the prosecutor was willing to drop the case rather than let the case file come out into the light. I don't think I need to draw the connections here to Adnan's case. We've talked about this a bunch before. Moving on to the state of Maryland versus Rodney Addison. Detective McGillivray was one of the detectives on this case. Rodney Addison was 23 years old when he was convicted of the murder of Lewis Jackson in 1996. Addison was sentenced to 30 years in prison, but after 9 years, he was determined to be wrongfully incarcerated and he was released. Addison was convicted on the strength of a single eyewitness who said she'd witnessed the shooting from her apartment bathroom window and she identified him in a lineup. However, there were 3 other witnesses to the crime whose statements did not support the eyewitness's statement or the theory that Addison was the shooter. But those 3 statements were not provided to the defense. At trial, the eyewitness testified to how she'd seen the murder. At the trial in 1998, Addison even interjected the court and said, "I think I can prove that the witness was lying on the stand yesterday when she said she looked out her window." But 2 days later, he was convicted. But he was right. The witness's window did not give a view of the shooting. In 2005, at his post-conviction relief hearing, the eyewitness and her mother testified that the eyewitness had not seen the murder. They said she was busy getting high and shooting up cocaine at the time, and that window did not actually show the place where the shooting had happened. After Addison's conviction was overturned, the prosecutor's office declined to recharge him, but they stated that it was not an exoneration and it didn't prove he was innocent, just that the evidence wasn't there. Colin then summarizes another case where a very similar thing happened, and a person was convicted even though all the alleged eyewitness could see was a Donkey Kong video game and not the place where the crime had actually taken place. That person was also wrongfully convicted and eventually released years later for a crime they didn't commit. It's another example of a time the police knew the witness could not have seen what they said they saw, but presented the evidence anyway, and didn't disclose all of the information to the defense. Okay, Terry Jones. In March of 2004, the body of a girl named Antiona Mills was found battered, naked, wrapped in a sheet in the middle of a road in northwest Baltimore. She was a 9th grader at a local high school. About a year later, Terry Jones was charged with her death. Police said that they found what they believed to be his DNA on the belt around her ankles. They said that Jones was her boyfriend and that they'd met up the day before her body was found based on phone records that showed they'd exchanged phone calls that day. Another person named Eric Barksdale was charged for the murder. Jones's attorney said that Barksdale's DNA was also on the belt and that the two men were together at the time Mills was killed. So they were both charged in 2005, but they were both eventually acquitted. The state's case was based almost entirely on the DNA evidence. It turns out, though, that the prosecution did not hand over the protocols for how the DNA testing had been conducted until the day before trial. They also lied about when and how they'd given the protocols to the defense. And when the judge found out that the defense hadn't had that information at the time the prosecution said they had the information, she decided to throw out all of the DNA evidence. The prosecution objected on the grounds that the DNA evidence was really all they had, and the judge relaxed her ruling a smidge. She said that the state's crime lab results couldn't be admitted, but they did allow limited testing by an independent agency to be admitted. Well, the jury was not convinced by that testing, and both defendants were acquitted. It turns out that the state's DNA match was totally bogus, because they had an actual match a few years later. It turns out that Antiona Mills was murdered by a serial killer named William Vincent Brown, who was responsible for murdering or attempting to murder at least 3 women and dumping their bodies in Lincoln Park. He was convicted of multiples of these crimes, including the murder of Antiona Mills, based on sound DNA evidence. What we don't know is how the prosecution came to believe that they had Jones's and Barksdale's DNA on Antiona Mills's body. Given that the protocols weren't handed over till the last minute, it seems like whatever those procedures were made the results unreliable and impeachable, and the prosecution did not want the defense to know that. Okay, State of Maryland versus Toni Dewitt. In July 2002, Shireen Moore died of a single GSW to her chest in what seemed like a drive-by shooting. Someone named Maurice Booker was also shot, but he survived. The shooting took place on the porch of a house. Maurice's sister, Tasha, testified that she'd been on the porch, but went inside to make a phone call right before the shooting. She didn't see the shooting, and when she heard the shots, she fell to the floor and waited. The state said that wasn't actually true, and that she'd picked DeWitt's face out of a photo array, and that she'd seen him jump out of a car with a gun and run through the alley next to the house. But Tasha testified that the only reason she signed the photo of DeWitt in the photo array book was because investigators, one of whom was Detective McGillivray, said to sign it if you know him. She also said that she was scared and she felt threatened by Detective McGillivray, and she only signed the array so they would let her go. McGillivray, of course, denies threatening her, but admits that he was fully aware that Tasha was not an eyewitness to the shooting, and he had only asked her if she recognized him in the photo array. That's weird. Why do you care if she only recognizes him? Maurice, the one who was shot and recovered, was also shown a photo array. Next to DeWitt's picture, Maurice wrote, "He shot me." According to Maurice, though, he only wrote that because the police told him that unless he identified DeWitt as the shooter, his mother and sisters would be detained, and his sisters and nieces would be put in foster care, and his brother would be prosecuted. McGillivray didn't do that particular photo array, but the 2 detectives who did deny any threats being made. However, one of the detectives did admit that Maurice had told him that other officers in the case had made promises if Maurice indicated DeWitt was the shooter. This begs the question, why would the victim of a shooting say that he'd identified a guy that didn't shoot him, unless he was actually being coerced in some way by the police when he identified that person? At the time of the podcast, Dewitt had had a post-conviction relief hearing about a month before. They were waiting for the ruling on that, and I tried to find out what happened, but I couldn't. If you go researching and you find out, come back and let me know. All right, one more case. This is the state of Maryland versus Brian Cooper. Brian was 18 years old when he was arrested for murder in connection with the stabbing of a guy named Elliot Scott in 2002. Cooper was arrested in May of 2002, was put in a secure interview room, and Detective Ritz started his interview of Cooper that evening with no Miranda warning given. Ritz apparently started by rambling on about the crime and what his investigation had uncovered. When Ritz was asked to describe his process or procedure of interrogation, he said a few things. He admitted to rambling on about the investigation and that he had an arrest warrant for the murder. He told him the location, that he'd spoken to several people who'd identified him as the person involved in the incident. Ritz says he gave Cooper some background information on the victim, portraying him as not necessarily a nice guy, saying there's two sides to every story, that he had witnesses who'd seen them arguing earlier that evening, that he had witnesses who'd seen Cooper get out of a vehicle chasing the victim that evening, and he kept reiterating that there are two sides to every story. Cooper just sat there. It wasn't a question and answer type thing. Ritz just rambled on for like an hour and a half. At that point, Ritz says he showed Cooper the face page of the arrest warrant, kind of like Adnan had been flashed just that front page of the arrest warrant. And in this case, there was about a 2-inch file sitting on a desk in the room where Cooper could see it. Cooper decides he wants to tell his story, and Ritz doesn't tell him to stop or give him a Miranda warning. Cooper goes on to explain how he was arguing with the victim at one point in the night and did see him later in the night, but did not stab him. Then Ritz gives Cooper the Miranda warning and records his statement. So Cooper gives a more detailed account of the night, which is used at trial. Ritz said he used this technique to gain Cooper's trust, and because he didn't want him to shut down before giving him the Miranda warning. Cooper is convicted of the murder, but the appellate court ended up overturning it. The grounds for overturning it are Ritz's interrogation technique, which is known as a two-step interrogation technique. In other words, there's the first interview, where the person partially incriminates himself without being Mirandized, and the appellate court said, no, that's improper and violates Miranda. There's even a Supreme Court case ruling that specifically says that this is an improper way to do an interview. It creates a huge possibility of false confessions because they're feeding the suspect all of the key details of the case before the person ever goes on the record. Now, this should remind you of a lot of things that went on with Jay. There wasn't just a two-step process, there was about a billion-step process, including lots of details that changed between his pre-interviews and his recorded interviews and then again at trial. They got him in, they got his trust, they got him to partially incriminate himself, then they Mirandized him and told him he either comes clean with the information they want from him about Adnan, or he gets convicted of the crime himself. The big question is, did Ritz go through the same rambling discourse with Jay that he did in the Cooper case? Well, he says that's his interrogation technique, so it's reasonable to believe that he might have. Of course, Jay had also learned a lot of information from the news, so between those two things, it's hard to tell what information Jay knew and what information he got from other sources. Rabia wonders if they did the same thing with Adnan and suggests that they must have, because Adnan said later that the police said things to him like, we know you had red gloves on, and that they told him that Hayes' car was at the park and ride. So to a certain extent, it seems like that's the way Ritz does his interrogations, despite knowing it's improper. So there are a bunch of common themes throughout all of these cases. There are the officers involved and the fact that all these cases are in Baltimore. We have witnesses being offered deals they can't refuse. We have police ignoring witnesses and leads that could have been very useful with no explanation or reason for why they're being ignored. We have a failure to test or selective testing of forensic evidence. And we have withholding of exculpatory evidence that should have been given to the defense. Finally, Cowan says you don't have to take their word for it. There's a guy named Michael A. Wood Jr., who's a former Baltimore police officer who served from 2003 to 2014 and has recently gone public as kind of a whistleblower. He has come forward to say, here are all the things I observed during my time on the job in terms of obtaining false confessions, manufacturing evidence, and creating narratives that don't exist. Rabia then refers to the TV show The Wire, which is fictional, but the guy who wrote it, David Simon, spent a year embedded with the Baltimore police before writing it. And there's a scene in the first season where they're trying to get someone to identify her shooter, and they tap on the person they know, or think they know, who did it. So, take from that what you will.